You can see they are going to come out.
Okay. Have you?
Yes, they are coming out.
So the other case is a report of service. Oh, we've done this one. So.
Yeah, number 15.
Okay. Thank you. 15 years we have. What of number 7?
You are true with it.
Number 8?
You are true with it.
9?
You are true.
Then it remains 12.
You are true with it.
Where?
So it remains number 13.
13, 14.
You want to do 14 now.
Okay, 14 is polarized. Okay, what of 13? Okay. So just before we start the virtual hearing, who is here for Eco Brand? It's for hearing of motion. Okay, I can hardly hear you. Okay. So how is it?
So now we're able to start take the day and see that whether it's not family. What are the things I feel for both of them?
Who is on the other side of it? You are only here alone. Because if he was here, we could have just given you a date within which you do what you said you are going to do, so that you won't stay here till after the virtual hearing, before hearing from you. Very well. Because we are going to start now. They have all logged in. Okay.
The panel.
Case number NSF/LA now 288/2019 between Mr. Paul Aribo and one Mobi Producing Nigeria Community. 2. Esowe Mobi Corporation. My Lord, parties are absent, Madam.
Now, who are those online?
The second
John Christo. Who is he? Eh?
the witness.
Okay. I think I saw him here something. So, but who is the other gentleman? Okay. So call it again. Let us see.
Case number NSF/LA 288/2019 between Mr. Paul Aribo and one Mobi Producing Nigeria Community. 2. Esowe Mobi Corporation. My Lord,
Yes.
claimant absent.
Mm.
4th defendant absent, my Lord.
Okay.
2nd defendant represented, my Lord.
Okay. By who?
By who?
Max.
Max.
Okay. Philip Miles is here. Yes, Philip Miles.
Are you-
Philemon. Okay. Appearances, please.
And I love you.
Yes.
My Lord, my name is Esowe. But appearing with me for the claimant. Juliet wants to. And David Chikere. Was a Muslim.
Good. Yes. 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 Okay. Very well. The matter was adjourned to today for continuation of hearing. So there was a cross-examination of the other day, but it was cross-examination of Philip Miles Philemon, I think, because he is the DW2. Today is DW2 was cross-examined. Did we conclude the cross-examination of the CW2? We didn't. Okay. DW2 is Mr. Philip Miles. Is it? Okay. So, Mr. Miles Philemon, okay. Please remember that you were sworn before you started you are still bound by the oath you took. Please say the truth, the whole truth, and nothing but the truth. Okay. So, you were the person cross-examining.
That's fine.
You listen very well. You are still to be fully cross-examined. What is the show?
Good morning. Over there.
My lord, I can hear you very well, but it's very difficult to hear anyone else.
Okay. Yes.
So I will start with the letter dated November 28, 2028. 2019, that's the letter you're using giving incentive to the claimant, Paul Arinze. Would I be correct to say that the second defendant granted financial incentive to the claimant, who is a total stranger to it?
Is it possible for you to display the letter you're talking about?
I can't hear it, right?
You said, is it possible? Say what you said again.
I'm making reference to the incentive. The last time you said incentive was granted to the claimant. I'm asking now that will I be correct to say that the second defendant granted financial incentive to the claimant, a person that it claims is a total stranger to it? That's the question.
Did you get it?
Yes, the second defendant did grant a financial incentive to the claimant. That's correct. I believe the word stranger in our defense is the statement about the second defendant being a stranger to Nigeria and not doing business in Nigeria.
Did you get it? Did you get it?
He said he admitted that the second defendant granted incentive to the claimant.
Yes.
He was now explaining the second side,
Yes.
the word stranger.
Yes.
We're a stranger to Nigeria, but I believe the claimant signed the document, the agreement, the restricted stock unit agreement. And so stranger would not be an appropriate word given that contractual relationship.
Okay. All right.
The reason why I'm asking using the word stranger, please, if you don't mind, in paragraph 45 of your deposition, you stated that the second defendant does not have or maintain in his record the personal data of the claimant regarding his retirement. Will I be correct?
That's correct. That's my statement.
The witness said that is correct.
It is correct. Yes. So,
Please confirm to this honorable court at what point was the incentive meant to stop? At what point was the incentive meant to stop? The incentive granted to the claimant, at what point were they meant to stop?
You said stop? Is the last word stop, S-T-O-P?
yes. Said, yeah, this says stop. STOP.
Yes, stop, yes, or determined. Are you still granting the claimant incentive today?
Well, I'm not sure what you mean by stop, but the last incentive he was granted, whenever that was, would have been his final incentive. But the award is different than the delivery. And so the delivery could continue as long as the person remained in good standing with the first defendant.
It said the incentive is supposed to, or whatever you call it, is supposed to continue on as long as the person is on good standing with the person who granted it. That's the first defendant.
Well, we were the second defendant was the one who granted it. And then, of course, they would have to remain in good standing with us as well.
Does that make you happy? Please, I'm asking you, you did not employ the claimant. So you claim, am I correct?
So you did not employ the claimant.
Did you? The second defendant did not employ the claimant. That's correct.
Is the second defendant paying somebody he did not employ incentive that are conditional upon his employment with somebody else? That's the question. You're a lawyer.
It's not conditioned on his employment with the first defendant. It's conditioned on his remaining in good standing with the first defendant. And he could retire or he could leave in some other way that let him remain in good standing. And the delivery of the incentives that were granted prior to his separation could continue to be delivered.
He said so before. He said, so long it was granted, and as long as he's in good standing with the
first defendant.
The first defendant.
Oh, that's beautiful. Thank you very much, good man. So, will I be correct that the incentive the second defendant granted was granted because they had knowledge of and had interest in the claimant's employment status? Yes or no?
I'm sorry, could you say that again?
Will I be correct to say that this incentive that the second defendant granted the claimant, they had, before that incentive was granted, they had a knowledge of and had interest in the claimant's employment status? Yes or no?
Can I correct something I said?
You can, but unfortunately, you cannot correct me. I will ask questions and you would answer my questions. Either you are aware.
No, I want to answer
my questions. My questions cannot be wrong. And you're a lawyer, you should know that.
No.
You listen again. Please hold your peace. Listen again. You are the second defendant. You are granting incentive to somebody you did not employ. I'm not asking you. Will I be correct to say that for you to grant somebody you are claiming you did not employ incentive, you will be interested in and aware of his employment status? Yes or no?
I believe that we would be aware of certain elements of his employment status, but not all elements. And the thing that I'd like to correct is one of the conditions of those awards is that somebody doesn't engage in detrimental conduct. And it's possible for those awards to continue even if somebody did not remain in good status with their employer, but they could still be granted if the second defendant wished to continue them. Like it's the choice of the second defendant as to whether or not to continue delivering those awards. Like, does that make sense?
He said well, he's saying he's not understanding what you're saying.
Well, let me try it this way. If it's possible for the second defendant to continue delivering the awards,
it's possible for the second defendant to continue the award, just giving that award, so long as
even if the recipient, the claimant, did not continue in good status with the first defendant.
Even if the claimant does not continue to
claimant the first defendant. So please, can you explain to this honorable court why, of all persons in Nigeria, the second defendant elected to give incentive to the claimant? On what basis was those incentives based on?
The grant was given originally due to the indirect contributions. Let me put it this way. The claimant, through his employment with the first defendant, indirectly contributed to the success of the second defendant. And so the second defendant gave an incentive to help maintain alignment with the goals of the shareholder. And I think it says it. There's several documents, but the letter, the 2003 incentive program, the special provisions, and the overview talk about alignment with the goals of the second defendant. So there was an indirect contribution that the claimant made.
I don't think get that. I'm hearing indirect. My question is very
There must have been an indirect contribution that the claimant made.
must have been an indirect. Do you
Contribution
have
that
any evidence of the indirect
that's
that made the second defendant to grant the claimant its restricted shares unit? Why? What was those indirect involvement?
I don't know what the indirect contributions were, but if you look at the overview, it says in that document that the program's intended to help reward, retain, and motivate selected employees of the corporation and its affiliates, and to further align the interest of those employees with the interest of the corporation's shareholders through the grant of stock-based awards. I honestly don't know what his specific contributions were to the first defendant that indirectly benefited the
Mr.
second.
Freeman, please.
I'm sorry.
I think your answer should be very short.
Okay, I'm sorry.
Yes, because if that is
Would I be correct to say that the award of those shares are discretionary or on the second defendant? Your word, they were discretionary. Am I correct?
The awards were discretionary, that's correct.
Well, confirm that they are discretionary shares.
the award, yes.
Discretionary shares are awarded.
Yes.
But he doesn't know why those shares are awarded.
Discretion. And the second defendant.
So can you please tell the honorable court how the second defendant of over 300 million Nigerians identified the claimant and awarded him shares until his employment was terminated by the first defendant? Can you please tell this honorable court how the system in your organization in US used in identifying a Nigerian citizen that you have no business with and awarded him shares for 10 years? Can you please tell this honorable court the system you use?
I don't know exactly how the first defendant communicated to the second defendant, but it would have been based on information that the second defendant received from the first defendant.
He said it does not, that it not serving the way for some information that the second defendant received from the first defendant. Yes.
You are testifying about events that occurred in Nigeria, a country you admit that the second defendant has no operation in. So if your direct personal knowledge of events in Nigeria is limited, are you aware that your direct personal knowledge of events in Nigeria is limited? Are you aware?
My
Yes,
lord,
have
my
you been
lord,
to have you been to Nigeria yourself before?
my lord, I
Have you
can't
been to
hear.
Nigeria yourself before?
Have you been to Nigeria before?
Yes, I went there one time.
Yes, you have been to Nigeria. The event that led to the termination of the claimant's employment, they are not aware of them. Am I correct that you are not aware of those events?
I'm not aware of what led to his termination by the first defendant.
Not aware of those events that led to the termination of. Not aware. Is the second defendant aware of the event that led to the termination of the claimant?
I don't have any knowledge of that myself.
You don't have knowledge if the second defendant is aware.
Do you know if
I
the second
don't-
defendant is aware?
I don't have any personal knowledge as to whether or not they're aware of that. But I would assume that the events that transpired were communicated to the first defendant. I'm sorry, communicated by the first defendant to the second defendant. I don't know the facts and circumstances, but I assume that the second defendant is aware of them through information received from the first defendant.
Yes.
So, finally, my lens in yeah, we refer to our seniors as seniors. Thank you. You cannot tell me from your personal knowledge about the claimant's day-to-day duty. Who supervises
My lord,
can you tell me something about the claimant's day-to-day duty? One, who supervised him? Two, and what were his responsibility in Nigeria? Can you tell me something about who supervised or claimant's day-to-day duty? Who supervised him in Nigeria? And what was his activity in Nigeria? Can you tell me something about anything about the claimant as well?
at one time, I read the complaint, but I don't recall who his supervisors were. And I don't know if there was anything about that in our answer or not, but I don't have independent knowledge of who he worked for in Nigeria.
Thank you. Finally, have you met the claimant yourself?
No, not that I recall. I mean, it could have been 20 years. It could have been 20 years ago before any of this came up.
Thank you very much. God bless.
Any re-examination? Re-examination.
Mr. Pilaman, in a nutshell, can you explain an employee under the restricted stock units of the second defendant?
Come again. Come again. Come again.
There were questions all around.
No, I just want to know what is trying to ask so that I know whether to sustain your objection.
There were questions back and forth on employees and incentive awards.
Second defendant and defendant.
So I wanted to ask the defendant to clarify for the purpose of documentation who an employee is under that incentive award.
Well,
If you kept saying he was not understand, cannot hear. So I get very well now.
I think I'll sustain that objection. Because okay. All right. Yeah. Thank you. I think they're done with you. There's no more. Yes. Thank you very much.
Thank you, and I'm sorry I couldn't hear some of what was going on, and thank you for helping me with that.
Okay.
Bye-bye.
Okay. The second counsel is going to cross-examine you. Yes.
My lord,
You're the counsel for
the first defendant.
the counsel for the first defendant is going to cross-examine you.
Okay,
Yes.
thank you.
Yes. Yes.
And that is the case of the second defendant.
Oh, you're not cross-examining.
That is the same thing. You won't cross-examine. We are the same the evidence of the second defendant.
Okay, he relies on whatever.
National one is moving.
Yes. Okay, there's no more questions. The council says it has no questions for you. So
Okay.
that's your case. Case for the
So I should leave, is that correct or no?
no more cross-examination, nothing. They've done with you. They are done with you. So
Okay.
you're hereby discharged from further appearance.
Thank you again. I appreciate your help. Thank you.
Very well. Okay.
And that's the case of the second defendant.
Case for the second defendant.
Yes.
So that means this is the end of the hearing. Okay. So we'll start from the defendant. You have 21 days within which to write and serve your final written address. Okay. And upon receipt of same, 21 days within which to file and serve your final written addresses upon receipt.
Defendants period is simultaneous. There are two defendants.
Yes, there are two defendants. I think they should be simultaneous because he wouldn't depend on what you wrote. He will give his final, he will give the final address on what he presented.
21 for both of them. 21 for them.
Yes, 21. No, the defendants, there are two. It's 21 days for them, for the two of them. They will write and file and serve you. Then upon receipt, you have 21 days also. Yes, so he's the claimant. Okay. Both of you will write and serve him. And upon receipt, he will have 21 days. Let me see. This an okay. So yes. No, let's go November, because we are this long vac is late in coming, because we've never stayed up to 30th July before long vacation. So this one is coming 31st of July. So we don't know when we'll come back in October. It may be the end. So let's go November, early November and all that. Yes.
I know, November 5th.
5th of November. I wish I can hear you well.
Then by second week, I don't have a record. Record of proceeding and after second, then.
You want the record of proceedings of who?
And the witness to the second defendant.
That is this one?
Yes,
And which one again?
The record of the second witness and the first defendant.
Okay. You were not here?
They tend to rely on that, the record of the reports. So we are part of the record of the report.
Okay.
So I don't think-
I know you will put it in writing.
Therefore, we are the application.
All right. So, when do you think they can adopt this thing? November.
Yes, madam.
Let's go within, because by the time he gets his record of proceedings, maybe middle. Um,
10th of November.
10th of November. How do you stand on the 10th of November? It's because of your asking for record of proceedings, because I'm sure it will not be too easy.
And I have a lot of bring a notice of this honorable program and they bring in an no cost application at this stage. The first claimant moving. The first defendant has the ceased to exist and name as it is. I was no longer moving Nigeria. That goes by the name of settler. So we are constrained to bring an application to that such that the judgment of this the ban.
It will not read mobile, and there will be nobody to.
Yes, my lord.
Okay.
I just wanted to mention it for at the appropriate time to bring it down.
Okay.
Great to know.
Yes.
Yes. Great to know.
So this matter is finally adjourned to. No, it's not finally. The matter is adjourned to 10th day of November 2026 for the adoption of the final written addresses of all the council to the parties. Yes. Okay. Okay. So the other one. You said you're applying for something. You better do it timeously. Okay. Is there anybody who hasn't taken?
Yes, it's really one more time.
Which one? Thank you.